full-time bar, having spent 6 years working as a solicitor, specialising in construction and commercial disputes. His extensive knowledge of adjudication and arbitration as both the client's representative and decision maker. Robert is also an accredited mediator and chartered arbitrator in several UK and overseas panels. That is your panel this morning. We will be taking time for questions, so please use the Q&A button. I see someone's already posted one question there. So we'll kick off with our first question, which is a leading question. What is diversity? Robert, would you like to kick off with that one?
Thank you, John. Thank you, Jonathan. Yes, of course. I suppose one would start initially by looking at a dictionary definition of diversity, which in the one I've picked up says the condition of having or being composed of differing elements, especially the inclusion of people of different races, cultures, etc., in a group or organization, organizational programs intended to promote diversity in schools, for example. Now, that is a very wide definition. What are we defining diversity? I actually picked up the Chartered Institute of Arbitrators Equity, Diversity, Inclusion Strategy, which says diversity, the condition of having or being composed of differing elements. So I think what we're looking at here when you're defining diversity is inclusion of everybody, no matter what their background, their gender, or anything else. Obviously, when we're looking at diversity, one shouldn't forget that we need someone who actually knows what they're talking about as well. But it is overall inclusivity.
Thank you. Does anyone on the panel want to add to that? Well, actually, that brings us on to a question that we've had from Seth Hanley. Seth has, in the first group discussion, do the panel consider diversity as including adjudicators from different disciplines, i.e. surveyors, solicitors, barristers, engineers, architects, as well as diversity protected by law with regard to age, gender and orientation? And I can see Sean would like to answer that question. Sean? You there?
I am. I didn't mean to answer it, no.
Oh, right, sorry.
It's okay. I can address that. I think the answer to that, what Seth posed, is yes. UK Adjudicators try to do it. And I think a lot of the other bodies that act as adjudicator nominating bodies are trying to do it. And it's not just in the United Kingdom. If you look at the FIDIC presidents list now and the current work that FIDIC are doing in terms of their credentialing to enable people in other countries that aren't adequately represented at the moment to get onto their panels. So I think it's a global movement of recognizing that you do need diversity, and what was the exception to becoming the norm, and people's attitudes have totally changed. And I'll try not to interfere with the panel again. Sorry.
Sorry, Abdul, your hand's up.
Yes, well, I think just to add to what Sean was saying, I think it is critical to have diversity in the broadest possible sense when it comes to tribunal. I mean, for a number of reasons. One, the confidence of the parties in the process, and secondly, to ensure you get the best possible results. I think it certainly helps a tribunal, whether it's arbitration or adjudication, to have the broadest possible experience relevant to the issues in dispute. So I'd agree with the question that diversity means many things, but included amongst that has to be diversity of professions when it comes to dispute resolution in the construction industry.
I'd agree with that, Abdul. I think one of the benefits of the adjudication process is that the adjudicator, and the same with arbitration, that they're invited to draw on their own knowledge and experience. I was involved in an adjudication where there are allegations of professional negligence being made against an architect, and we had an architect as the adjudicator, and they were able to really understand and get to grips with the allegations that were made. And also it actually, we didn't, it was a low value adjudication. We didn't involve expert evidence. We in fact both parties invited the adjudicator to act as expert in determining whether or not they considered the standard of performance had fallen below what was expected. So it can be beneficial in a number of ways, having people with diverse experience, diverse backgrounds both in terms of saving cost, in terms of confidence in the panel, and in terms of bringing that level of expertise.
Robert, I can see your hands up.
Yeah, indeed. I was just going to go back on the comment about FIDIC, because actually, if you look at the numbers of the presence list, which I am one of the 60 members of FIDIC adjudicators, 28 of them are from the UK, which means that 32 of them are from abroad, from quite a list of different background countries, but in ones and twos. So there's quite a lot that we need to do. And if you split that down even more, only 4 of them are female. Whereas the white males are 52 and the non-white males are 4. So FIDIC are doing or trying to push matters forward, but I actually think, as with most other organisations, there's quite a long way to go.
Okay, well, let's take it on to our next point, which is diversity in itself is a diverse concept and is multifaceted. How far does diversity in tribunals need to go? Gender, age, experience, culture, and nationality. Sharon, can I ask you to take the lead on this one?
Yes, thank you, Jonathan. Diversity in the tribunal is exactly what is needed for a fair and balanced decision. Unfortunately, it seems the world of arbitration is still dominated by what is commonly referred to as the male, pale and stale decision makers. So in that sense, tribunals are not gender, age or culturally diverse. So I think diversity in tribunals does need to be increased. However, first and foremost, tribunal needs to be able to do the job. So knowledge and experience is really top of the list. But by no means does having younger or female tribunal members mean that you lose out on the knowledge or experience or the ability to reach a fair decision. Perhaps the younger generation might be even more open-minded with a fresher view than the stale mind, as it were. I suppose one way of enhancing tribunal legitimacy would be to ensure greater diversity among the tribunal. I think this would definitely improve people's perception of the fairness and the impartiality of the arbitration process. So the more diverse a tribunal, I think the better for everyone, really.
No, I agree. Chantelle, what do you think about that?
Hi, Jonathan. Firstly, thanks to UK Adjudicators for inviting me to speak today. And I, of course, look forward to seeing everyone at the networking event later. I think, Jonathan, before I answer the question, I'd just like to mention that the views I express are my views and not that of the UK. I think if Sean knew what my views were on this topic, he might have allocated me to a different speaking slot. So with that in mind, I'm going to try and answer your question. So I think in order to answer it, we have to look at what is the purpose of having diversity in tribunals. Is it simply to promote equal opportunity, or is the purpose of promoting diversity in tribunals to achieve different outcomes? I say this because, I mean, I've read so many articles about diversity in boardrooms, diversity in law firms, and generally diversity in the workplace. And aside from promoting equal opportunity in the workplace, the motivation for promoting diversity in boardrooms are to have diverse perception in commercial environments, so diverse views on solving problems. Now we have to ask ourselves, is that important in a tribunal? So if diversity in tribunals is connected to equal opportunities in the workplace, then my view is that there's no obligation to ensure diversity in tribunals. We do not work together. There's no workplace, so to speak. In fact, we're all in competition with each other, and parties seeking appointment on tribunals are doing so in competition to the next person. If it's a panel appointing a nominating body, then I do not think personal attributes, and to an extent demographic attributes, should play a role at all in selecting the panel. What should, however, play a role, in my view, is experience and possibly nationality if the dispute is international. If you are hoping to achieve a certain result or a different result by having a diverse tribunal, then there's a problem. So in my view, only experience should be taken into account insofar as diversity in tribunals are concerned. And I mean diverse experience. Yeah. So.
Yeah, that's an interesting view. Abdul, what do you say about that?
Yeah, well, can I disagree a little bit with Chantelle on that?
Please.
I mean, there is an assumption that you have a binary choice between diversity and experience. And to a certain extent at the moment that's true, but it becomes a chicken and egg situation. If you're focusing solely on experience, as Sharon mentioned earlier on, the problem you have with lots of tribunals when it comes to decision-making in the construction industry is that they're white and male and pale. And if you're looking for experience, and if experience is the only criteria you use, you're going to keep picking the same individuals, and it becomes, as I said, a chicken and egg situation. You don't pick somebody who is not white and male because they don't have experience, and people who are not white and male don't have experience because they're not being picked. So you have that problem. And there is, I think, a fundamental issue with legitimacy, particularly in international arbitration. If you have panels that do not look like the parties, then increasingly the whole system of international arbitration will come under strain. There's a very good example of that, which relates to Nigeria. I mean, the PNID decision, which I'm sure most people have heard of, which a decision that went very much against the Nigerian government. And there was a groundswell within Nigeria that why are we submitting our disputes to international arbitration, where most of the, in that case, there was one Nigerian arbitrator and two non-Nigerian arbitrators. And there was an issue about the legitimacy of that tribunal. Now, if we want the system of international arbitration as we see it to continue, we're going to have to address issues of diversity because it goes to the question of legitimacy. People would not want to submit their disputes to international arbitration if they don't have confidence that their issues, their points of view are going to be represented on the tribunals making the decisions.
Thank you. Robert, your hand's up.
Yeah, just following on from what Abdul said, and he is absolutely right. Diversity is important to make sure that the parties feel confident in the decision-making process. But of course, it can also be used to the contrary position, where you're trying to swing the tribunal in a particular direction. And it does seem to me that it is important that you have the right experience for the decision maker, whomever they are, from whatever their background. And I have to say, and I fully expected this to come up, the term pale, male and stale is in itself diversive. And it actually indicates that those who are white, Caucasian, if you wish, decision makers who are male are in some way not as good as others. That's the impression it gives. Of course, that's just wrong. The reality is we should get rid of those sorts of terms and deal with diversity in a straightforward way. Do we need diversity on the tribunal? If so, what are the parties' choices? And of course, it's got to be the right experience.
Thank you. There's a few people nodding there. But Chantelle, do you want to say anything further or come back on that?
No, I think I'll answer later with my other questions. I'll just work in my answer there.
Okay. Well, let me take two comments from the audience. Just remind people, if you want to ask a question, please use the Q&A button. So first of all, for Geraint Wally, do you consider that a diversity of economic and social background is also important? Are we seeing a true diversity in this area? Does anybody want to comment on that?
Well, I think actually, I seem to be talking. I don't want to talk too much. Obviously, there are others on the panel. In terms of race, economic background, gender, sexuality, yes, of course, there is some diversity in those areas coming through in decision makers, but not enough, quite frankly. And in fact, most of it shouldn't matter in the decision-making process, save where there are cultural issues that impact upon the dispute itself, it seems to me.
Thank you. Okay, let's move on to our next point, which is, to what extent, if at all, does diversity impact on the role played by a tribunal? Chantelle, I think this might be one for you again.
Yeah. Well, again, I think that diversity should not have any impact on the role played by the tribunal. The tribunal's role should mostly remain the same in each dispute, depending perhaps on the nature of the proceedings. I read the Judicial and Inclusion Strategy 2020-2025 for the UK, and in the foreword by the Lord Chief Justice, he said the following, so I'm just going to read it. He said, it's just one little sentence. He said, a more diverse judiciary will capture talent that is currently lost to us and help cement the confidence of the public that the judiciary broadly reflects society. So I just want to focus on that last part where he says that the judiciary broadly reflects society. And I ask myself, should the same apply to construction tribunals? I'm going to use an example from South Africa, and you can decide for yourself, attendees, if the same applies to the UK or to your jurisdiction. So in South Africa, most construction companies are owned by men. Men as the owners of the company, take the dispute to arbitration. I'm going to leave race aside for the moment. But does that mean that the tribunal members deciding these disputes should be men in order to broadly reflect the construction society? So I actually don't know what impact diversity plays on the role of a tribunal, and I'm hoping none, because if it does play a role, then that means that the parties would choose certain diverse tribunal members in order to achieve a certain result. So today there are 6 panels, and of those 6 panels, 3 of them are chaired by women. I think there's a total of about 34 speakers. There might be a little bit less because I think some people speak twice, but of those 34, 8 are female. And of those 8, 4 are part of this panel. And I have to be honest, I don't really mind speaking about diversity, but there are only 4 other women on this panel speaking, or on this conference, speaking about topics other than diversity. So if you're interested to know whether gender plays a role, for example, on the impact of how panels interact or how the chairperson conducts the panel, then just have a look at today and decide for yourself whether being male or female does in fact play a role. Just lastly, someone once said to me, if they wanted to appoint a tribunal member who would be a stickler for the rules, they would appoint me. And I remember asking them, is that because you know me or because I'm female? And he said to me, well, because he knows me, but also because most females follow the rules, whereas men are a little less inclined to do so. And I thought, well, if that's true, then perhaps the role that a tribunal would play, depending if it's male or female, would be impacted by their gender. As I say, I can only hope that it doesn't, because your diversity, whether it be gender or ethnic background, shouldn't play a role in on the impact of the tribunal.
Robert, I think your hand was up first.
Sorry, Jonathan, I think I left it on for the last one, so move
Okay.
on.
Abdul,
Lower hand, go.
Let's go over to you.
Yeah, sorry, to echo Robert's earlier comment, I fear that I'm monopolizing some of this conference. I need to come back on a couple of points. I think there is, as I said earlier on, there is this idea that there's some sort of choice between diversity and experience and competence. I don't see the choice. The problem we have is that we don't have enough people on panels capable of being appointed by nominating bodies, etc., being chosen by parties to become arbitrators who are from a diverse background. And that's because we don't have enough people. I mean, there's a funneling problem, which is that there's a blockage somewhere along the system where you're not getting people coming through onto these nominating bodies, onto their panels, or coming to the attention of parties and being appointed by parties. You won't be appointed if you don't have experience. But you can't get experience unless you're appointed. So the fact that there aren't many, the fact that the panels, the nominating bodies, the tribunals are not diverse, is a function of in my view, the blockage in the system, that the fact that we're not getting sufficiently competent people coming through. I mean, speaking from personal experience, I know that in the jurisdictions where I work, in Africa, in Nigeria, in South Africa, in Zimbabwe, there are many, many very experienced, very good lawyers, QSs, engineers, who are more than capable of being excellent arbitrators, but they don't get on the panels. They don't get they don't get appointments for all sorts of reasons. And my second point is that this is it's I think we're all to a certain extent prisoners of our own experiences. Apart from, I mean, there is a central issue of legitimacy when it comes to diversity and the need to see a panel that reflects that reflects the parties from whom the disputes arise. We all would like to believe that the world in which we exist, where we all operate without biases, without implicit biases, without and we're entirely colorblind about the way we approach things. That's simply not the case. We are prisoners of our own experiences. And it's important, I think, if we're going to maintain the legitimacy of the process, to ensure that, particularly in international arbitration, that the tribunals reflect the parties from whom the disputes emanate. If we don't, then the system will collapse. People will walk away from the system if they don't have confidence in the process.
Thank you. There's been a flood of comments on this. I'll just read out two of them and I'll go over to Rachel, who's got a hand up. Just read out two. First of all, from Ed Rands. Ed says, it seems common ground that experience is a prerequisite for the tribunal. The CIOB has published that currently women take up 15% of the UK construction industry, with 2% working on site. BAME employees make up 6% of the workforce. And someone who wishes to remain anonymous has said, surely therefore to improve diversity in the tribunal, we need to improve the diversity of the workforce to be able to gain experience. If we select new tribunal members just to increase diversity, we in effect form some form of discrimination. And those are two interesting points there. Rachel, I think you wanted to come in there.
Yeah, I was going to agree with what Abdul had said in terms of it's really important for the parties to have faith in the tribunal and the legitimacy of the process and the legitimacy of the outcome. And also, I was going to agree violently with his comment about the difficulty to actually increase diversity on tribunals, because to a large degree, it is a bit of a closed shop. I was interested in becoming an adjudicator myself. I've been involved in large number of adjudications as a party representative. And whenever you apply to a nominating body, they say, well, what experience have you got as an adjudicator? And the answer is, well, none, because I'm not on a panel. And then they'll say, well, we can't let you on if you haven't got experience. So it's quite a frustrating process. And I know there's a large number of other people who have had the same experience. So I think the nominating bodies can do more to encourage people to join the panels, maybe having schemes of mentorship or things of that nature. And also, when I've spoken to arbitrators in the past, or people who sat as expert on expert determination panels, I've said, how did you get into it? And they've said, well, almost by accident. Someone who has been connected has asked me, would I like to have this opportunity? And then I've got in there. So again, it comes back to who you know, not what you know, in many occasions, in terms of ability to get onto a panel or get into a position of acting as decision maker. So and the fewer people there are who perhaps you have connections with that may reflect your background, etc., the harder it will become. So yeah,
hopefully
some personal experiences.
Rachel, hopefully it will get slightly better. Certainly with the Chartered Institute of Arbitrators, I'm actually on the board of management and chair of the panels management group. And we've been actively trying to ensure that those without experience get a chance to prove themselves and actually get onto the main panels. And one way of doing that is a mentorship scheme, which is also run. Not the easiest thing in the world to run for a relatively small organization. But there are efforts being made. I can't speak for any of the other large nominating bodies, but certainly that is recognised as a problem. How do you get experience and get onto a panel when there's a demand for experience? It's circular, isn't it? It doesn't work.
Yeah, Rachel, I had exactly the same experience. I think a lot of the smaller panels won't let you on because they say you need to be an adjudicator, you need to see done decisions, so you can't come on. But from my experience as well, I on the RICS, they do a course and then they interview you, and they do take on people who've not had previous experience. And for the first couple of years, they have someone who mentors you. So I know from my experience, the RICS is getting new people on by doing a similar thing to the CIArb. Chantelle,
sorry, I was just going to say with the RICS, they do tend to accept you if you do their course.
Yes, you got to do that. Well,
their
yes,
course.
you got to do their RICS adjudication course to get on. But yes, that is correct. Yeah. Chantelle, was your hand back up?
It was, but I loaded again. But it's fine. I'll say what I wanted to say.
Yes.
I think that everyone has the same problem getting onto panels, and it's not because you are a female or of a different race, or everybody has the same problem in getting the necessary experience. Now, if you're talking about diversity or achieving diversity on panels, in that you don't have the same people appointed all the time, then that's something different than saying you must have a panel that is diverse. Because I agree that we are all tired of seeing the same people being appointed over and over. And I can say, in South Africa, most of my arbitrations, I want to say 70 to 80% of them are in front of the same panel member, the same one person. And if he's not the only person on the panel, he's at least part of the tribunal. So I agree with the concept of having a diverse panel in the sense that we have different people being appointed. But I don't think that the element of diversity of a panel, for example, having one female, having one Asian person, and having one white person, should ever be something that should be considered, because that means you're trying to achieve a different outcome, or you're trying to bring different personal attributes to a construction or to a dispute. So I think I differ a little bit from the other views, but only because I don't think that I want to be appointed to a tribunal just because I'm a female. I want to be appointed to a tribunal because the parties have confidence in my ability. And I would rather maybe just call myself Chris from now on and not go by Chantelle, and people wouldn't know what gender I am. I mean, most of the time you don't even meet your adjudicator. And in fact, you make your submissions, the adjudicator gives his award, and that's the end of it. It shouldn't matter what color he is, or he, she is, or it honestly shouldn't matter. That's my view.
Okay. Bernadette.
Oh, yes. So I was just going to add on that the RICS do allow exemption from other courses, but only if they're within certain courses within the last 3 years. That's still an obstruction anyway, still is like an institutional obstruction, because there'll be people who have qualified as adjudicator years ago and kept up to date, but unless their course was within the 3 years, the RICS won't allow exemption. I mean, this was the understanding in about February this year, unless it's changed since. So you don't only have to do their course, but they will provide exemption. But again, there are hurdles to get over.
Yeah, I mean, I'm not part of the RICS, but maybe from them looking at their perspective, might be part of their quality control service, like the people they on the panel, they certain upstate the law and say it's protecting that the quality of the people that they're choosing. That might be a reason for it. Abdul.
Sorry, it's me again.
No, it's good to see you.
I was just going to say that I thought we were making a slightly more sophisticated argument point than just simply, diversity in a panel means you have to pick one of each. I mean, that's another point I'm making. I think the point I'm making is that the pool of people from whom you recruit has got to be broader, and sort of broad enough to make sure that when you do constitute a panel, there's a good chance that you have a good representation of various points of view on that panel. The idea of forum shopping, as it were, to try and pick, the right, the right person based on their attributes to get a particular result is not what I'm advocating. Let's be clear. I think what I'm advocating is to ensure that when we come to panels of arbitrators and adjudicators, there's a sufficient diversity of race, of experience, of qualifications, of gender, of sexual orientation, every possible facet of diversity, so that it reflects society. That when a choice is made from that panel, that there's a likelihood that we will get somebody who has some life experience, which adds to the deliberation decisions of the panel. So I think that's really what I'm driving at, rather than suggesting that there should be one individual on each panel picked based solely on the basis of their ethnicity or whatever else.
Thank you. I'm going to move on now to my next point, which comes on from this, is where would you place diversity in terms of importance when selecting a tribunal? And what are the most important factors in selecting a tribunal to determine a dispute? Should it be independence, impartiality, expertise, diversity? Rachel, can I go to you on this one?
Yeah, certainly. I mean, from my perspective, the most important thing is expertise. The person or people you have on your tribunal need to be capable of understanding and determining that dispute, and they need to do so in an independent and impartial way. Diversity isn't something, linking back to what Abdul's just said, it's not something I would use to pick a tribunal member if I was able to do so. I wouldn't say I want one of those. That's not what it should be. I totally agree with that sentiment. However, if the pool is very narrow, as he says, and it is narrow, let's be blunt about it, then you're going to end up with the same people. And it is perfectly feasible to forum shop at the moment. If you apply to certain nominating bodies and you specify certain attributes, you can almost name the person you're going to get, and people do that. They'll ask for, somebody who is a chartered engineer who lives in a particular region of the country who is also legally qualified. You're going to get one of possibly two people. It's and that shouldn't really happen. If you want to have a genuinely independent and impartial tribunal, that shouldn't be happening. It shouldn't be possible for one party to pick in that way. If you want to sort of narrow down who's going to be on your tribunal, it should be by agreement, where for example, in an arbitration, one party puts forward a list of names, the other party accepts one of those, and they agree on the attributes that person or people should have. But certainly in adjudication, I've come across a number of instances where the selection has been narrowed down quite easily by the other party picking certain attributes, and that really shouldn't be happening. And I think that the nominating bodies have got to do a lot more to widen that pool. And schemes of mentorship, I think, are a great idea, but how do we ensure that people are being taken on or mentored in that way? How many mentorships are offered, and who's being given them? I know that there's a number of adjudicators I've worked with in the past where they've taken on mentees and sort of looked after them, but that's come from a personal relationship that they've had, a personal connection that they've had with an individual, rather than a stranger having the opportunity to connect with someone with experience. So what opportunities are there for those that don't perhaps have those professional connections in order to get that necessary experience and to get on?
Do it.
Thank you. Actually, before I move on, Robert's got his hand up. Someone's made it.
No, I got the notes, not me. And there was a lot of backfeed today, so I knew somebody was recording again.
No, that was me. I pressed a Zoom invite, which opened. It's a recording in process, so shut the Zoom invite.
So can you, whoever's, can you go on mute, please, Damien James? Please, can you mute yourself? Thank you. Thank you, Rachel. Robert, before I go to you, someone makes an anonymous attendee makes quite an important point. He goes, what is your advice for young or new adjudicators, no experience as an adjudicator, who want to practice as an adjudicator? The prerequisite of the panel appears to rely heavily on previous experience as an adjudicator, and absent of that experience, the door is promptly closed. Are adjudicator panels a closed shop for already practicing adjudicators? Which is a point I think Rachel was making quite well. Robert.
Yeah, that is a good point. Hopefully the door isn't always shut, but it does feel that way many times, and certainly it was when I was trying to apply as well. And I just noticed a comment from Donny McKinnon, who said, is the pool narrow because many potential applicants are not willing to do the necessary work to get through? Of course, that's a slightly different question. There are many people who'd like to be decision makers, arbitrators, adjudicators, but it's actually quite tough, as it should be. You don't want decision makers who actually aren't up to the job. And there is a lot of work involved. And if someone isn't prepared to do that work, well, quite frankly, they shouldn't be the decision maker. So Donny, that may be the question. I think those who really wish to become the decision maker are actually prepared to put in the work. No, that was the only comment I wish to make there.
Chantelle, I'm sure you got something to say on this one. I'd like to hear your view.
Okay, so the advice for a new or young adjudicator, my advice would be is to make sure you are on panels or apply to panels, do all the courses you possibly can, attend networking events, speak at UK adjudicators conferences, and get to know as many people as you can. And in that way, you will be exposed to adjudications, whether you are party representative, and in that way, you will eventually build up to being appointed. But it's not going to happen overnight. It didn't happen overnight for the people who are being appointed. I mean, most of the parties that tribunal members that I appear in front of are quite old. They are not very young. And that's because younger people are not seen to have all of the necessary experience yet to be able to sit on those panels. Just like when you look at judges are older people normally, in my experience, because it takes years to build that experience before parties have faith in your abilities. So my advice is simply to get out there as much as you can. I've done every single course I can get hold of or that I can imagine. I speak at events. So just put yourself out there and get people to know you.
Thank you. Sharon, what do you say about that?
I think most of the comments I had have been covered. I think for me, as being an expert is quite similar to a tribunal, where you need, most importantly, to be independent and impartial. In terms of appointing them, I think, as Robert said and everyone has said, experience is absolutely key. You want someone who's able to do the job. Women or someone of a different ethnic background is not necessarily going to be nominated just as a token gesture. It should be on equal opportunity, but at the end of the day, you just really need to be able to do the job. And I think as someone like myself, as a younger expert than older ones, as Chantelle said, it is just getting out there and getting people to know what you can do, and that you do have the knowledge and capability to do it. And it comes with time that these appointments will come.
Thank you. Bernadette.
So I was going to say that, I mean, someone mentioned earlier, I think, not of the panel, a question that starting off as an adjudicator, but people should remember it is always a secondary profession. So it's getting a wide experience to begin with anyway. And I would always say, with Chantelle say, do lots of course, but specialize and find a niche, find something that no one else does. And then you can, find a specialism. Then you're more likely to be, well, you get your own speciality, then you're not competing with so many other people.
Yeah, I think that's good advice, actually. Thank you. I'm going to move on to the next point, which will be moving on from that. What can we do to foster more diversity of members on tribunals? Bernadette, I'm going to go back to you on this one.
Okay, well, I think some of the items have been covered, but I'm going to start off by saying was it Chantelle or no, Chantelle, for example, you said, oh, I see the same people all the time. Well, I'm going to say perhaps that it isn't only the institutions that have the issue, because Robert's already said that people are trying to increase at that base, but it's the people who are approaching the nominating bodies, the clients. Everyone maybe should be questioning at that point, well, okay, can I see who is on the panel? What is your strategy for diversity? I know it is also, it's experience and the knowledge is the prime reason for having a person appointed, but I think people need to take the lead and show as a consumer or a user of the panel that, you know, this is what we want. I mean, Chantelle was mentioned, is it a service or is it a workplace issue? But I think also the nominating bodies are providing a service to the clients and the people who are putting the name within the agreement. So I think it can be driven from everyone in the industry as well. I mean, I do agree that, I mean, you say the CIOB says only 15% of women and only 2% on site. Even of that amount, there's going to be so few who are even interested in adjudication, or even might not have covered it in a preliminary education. But I do think everyone needs to drive forward and question the nominating bodies. You know, what are you doing about it? Why aren't you opening the panels? You know, don't say to us, oh, because we don't have the demand. The demand for low value adjudications will increase if clients become aware of it. Some people don't even know about this low value adjudication systems are available. And then there'll be a need for more adjudicators, not saying, oh, we don't need them, we can't open our panel. I think also, you know, question nominating bodies, you know, why aren't you opening up your panels? Why are you waiting 3 years to do it? Why can't you do it on a rolling basis? I mean, all this needs resources and time, but I think we need to move forward. I mean, last night I got stopped outside the Tube with someone that handed me a flyer. It was Gorilla. I think it's a German company, 10 on 10 in 10. I haven't used it. I looked at the app, but it actually means, you know, they provide your vegetables from a dark warehouse and you don't know who you're getting. Fine, you don't know what adjudicator you're going to get unless you start trying to nominate one by picking criteria. But I think there needs to be a much more, and on this, I think there needs much more openness and transparency, and people need to say, this is what we're doing, you know, across the board, and keep up to date with the world, in effect, in very simple terms. And we're talking to a wide audience today. So, I mean, I know there is TEXA in the UK who make available their panel list. The RICS don't, but I don't want to, I mean, Robert, you're in the Middle East working there as well, so I don't know what the panels are like there. But I think there needs to be openness and transparency. I think everyone needs to push for that. And that's the only way we can, perhaps, not the only way, that's one way we can increase diversity, by people questioning, you know, why can't we? You know, why are we limited to what someone who might not even be fully aware of the consumers, the client's requirements are? And yes, it still will always go back to who's the right person for the panel, whatever color, creed, or orientation they are. But there's no reason why we still can't increase diversity. There's many disputes, and I think maybe people aren't being properly served if they don't have a wide enough range of people. That's my view.
No, thank
So
you.
Chantelle.
Rachel, can I go to you next?
I think I've touched on a few points in terms of what I think can be done to increase, foster more diversity and increase the pool that's available. I think the other thing that I would touch upon is regular review of who is actually on some of these panels. When adjudication first sort of took off in the UK, it was relatively easy for adjudicators to get onto these panels, demonstrate a certain amount of experience, and then get on. And once they're on, they're on. And I think we have all experienced a variety of standards of quality from adjudicators. Some are exceptionally good, some less so, some frankly appalling. Naming no names, obviously, and that shouldn't happen. We need to have confidence in the process and confidence in the quality of outcomes that are achieved. Otherwise, the whole process loses legitimacy. So I think regular reviews by nominating bodies of who is on their panels, looking at the standards of decisions making that is achieved by people on panels, and if people aren't up to scratch, either requiring some retraining or replacing them, frankly, and renewing those panels. And if you do that and open the door to others with suitable experience, then you will hopefully increase the diversity in terms of the pool of available tribunal members, but also increase people's faith in the process. I've worked for a number of clients who've lost faith in the adjudication process simply because the quality of the decision making hasn't been there, and that shouldn't happen. It's a great process when it works, and it shouldn't fall down because the tribunal member or members appointed to determine the issue aren't up to the job. I was involved with an RIBA review of adjudicators on their panel, and there was an individual who'd been on the panel from the outset, and we had to review a couple of their written decisions and see whether we thought they were up to par. And this particular panel member didn't know the difference between a statutory and a contractual adjudication, and throughout their decision confused the two. And the decision was appalling, and they charged, I think, £7,000 to the parties for this decision, and it's just not good enough. That panel member was removed, but I'm pretty sure that's not an isolated occurrence, and the same could be true of looking at other panels and the quality of decision making. So that's another thing I think needs to be done.
Thank you. Actually, Caroline Papers, the chair of TEXA, just commented that TEXA panel includes lawyers, engineers, architects, QSs, programmers. It's unreviewed. And as Bernadette said, there's the list of adjudicators on the website, and also then have the low value scheme. But Rachel, do you think there should be more regulation of the nominating bodies then?
I think, well, again, there's a little bit of a closed shop going on, isn't there? Because if you use, and it goes back to, I think, what the parties can do in terms of selecting the tribunal. If you look at a JCT contract, you've got a pre-agreed list of nominating bodies in there. The parties could select a different nominating body if they want, but the idea is you pick one of the ones that is listed and cross out the others. That's creating a closed shop. It should be the case that the parties themselves, when they're drafting their contracts, look at that list and consider how that nominating body deals with appointments and deals with keeping their panel members up to date in terms of experience and quality. And if they're not doing those things, perhaps the parties can drive that change by saying, you're not doing that review, I'm not going to have you as my nominating body. I'm going to select somebody that has this quality control, that has a system of mentoring, that has a more diverse panel, or is welcoming to new applicants. So I think the parties can drive that change, but I think also the contract drafting bodies perhaps could be a little bit more flexible in terms of the nominating bodies they put on that list.
Thank you.
And people shouldn't go in with a closed mind.
Thank you. Abdul, I can see you nodding there.
Sorry, well, I agree entirely with Rachel's comments, and also echo Bernadette's comments. I think we're going to find that this change is inevitable. It's going to be market driven. Big international conglomerates subject to ESG requirements are asking their firms of solicitors to demonstrate their diversity amongst their workforce. And when we are finding in chambers that is now working its way through to appointment of counsel and arbitrators. So the market is beginning to determine that, or to begin to make the decision that diversity is an important principle, because the ultimate client is subject to requirements that require them to demonstrate to their shareholders, to the public, that they are diverse in their workforce and diverse way to spend company funds. So I think the market's going to drive the change.
Thank you. Bernadette.
Yeah. So, well, in the market as well, I mean, on the commercial side of things, I mean, if the nominating bodies are being criticised or comments are coming forward that they're not diverse enough or that they need to make changes, then there's some some parties will say, well, I'm not going to nominate you anymore, and they'll lose out ultimately in simple terms on business. So that people do have to change. But that's the larger firms of lawyers can get involved with that. When you look at young firms of architects, they might just put in RABA, not really thinking about it. I'm not being critical of architects, but just saying they may not have sufficient knowledge about what they're even doing, or even think, well, I can call up the RABA and say, who is on your panel, or what are we doing, or even be able to explain to the client, what would happen if they did have a dispute. So it has to be market driven as well, but the people within the market as such have to know what they're asking as well. So it's across the board, and it comes back to the very beginning again, not only of getting younger people trained up or aware of adjudication in the early stage of the career, but more emphasis on what will happen when there's a dispute and explain to the client. I mean, clients don't even want to think there'll be a dispute when they're entering into a lovely new project on site. It's the last thing on their mind, as we all know.
Absolutely. Yeah, Robert.
Yeah, I agree with Bernadette actually. But she mentioned, and what part of the discussion has been about different parts of the world. It's not just UK we should be talking about. And as I do work in the Middle East, I have found that the panels in the Middle East do have quite a large number of local engineers, architects, surveyors on their panels. And more, certainly in the UAE, you have DIAC, and they are predominantly, from what I've seen when I'm acting as counsel, now if you don't choose an arbitrator, they are predominantly choosing more local arbitrators. So there is a market-led change going on, and certainly the panels in some parts of the world are definitely looking to have more locally qualified arbitrators. Certainly in the UAE, it used to be almost exclusively UK arbitrators to a large degree. But that is definitely changing. So I think, yes, it takes time, but it is changing. And yes, the market itself will dictate at some point.
Thank you. I'd like to ask the panel this question. How important do you consider the diversity of the tribunal members is to the parties involved in the dispute? Chantelle.
I just want to say I agree with what Rachel and Bernadette said, that at the end of the day, the parties hold so much power because at the end of the day, they appoint the panel or they choose the nominating body. And in doing so, I do not think that personal attributes of the tribunals even cross the parties' minds. I think qualifications do. I think especially if there's three members on the tribunal, they would pick one surveyor, one lawyer, one engineer or something. But I don't think that for one moment a party to a dispute thinks, oh, I want to have a female on my panel. At the end of the day, I think parties just want their dispute to be decided by a competent and fair tribunal. And as I said, I've never had a client who's indicated to me that a personal attribute is important. I always wonder when this topic of diversity in construction disputes come up, and I'm going to use this example, and I don't know that many places from England, but I'm going to say, how would a drywalling company from Birmingham, owned by a 50-year-old male, feel about appointing a 34-year-old Afrikaans-speaking South African female as an arbitrator in their dispute? And in debating this, I have to remind myself that the only attributes I just listed were personal and demographic attributes. And understandably, they may cause that company owner some distress, because he might think, how is this woman, Afrikaans-speaking South African woman, possibly going to relate to him and his 250-day EOT claim? But let's reconsider. Same set of facts. How would a drywalling company from Brim, owned by a 50-year-old male, feel about appointing an arbitrator who holds 2 law degrees, is completely bilingual, is a qualified international arbitrator, mediator, and adjudicator, and has worked on some of the most complex building disputes in more than 3 continents? On top of that, this arbitrator loves her job, his job, and has a real passion for construction disputes. And that is when I answer the question myself. It's the experience, including functional experience, industry experience, accomplishments, and education, which should always play the most important role in appointing a tribunal. Because just by focusing on my professional experience instead of my personal attributes, suddenly I sound like a great appointment. But because I think I sounded like a great appointment, Jonathan. I saw you laughing.
And I was agreeing with you.
But I think by focusing on the fact that I'm a female from South Africa who speaks Afrikaans is the wrong focus. The focus should be on my professional qualifications. So if the focus is on my personal attributes, then there's a problem. And I think that problem lies in society and not so much in the industry, if I can say it, because it's the company owner who needs his dispute decided. He's the one who holds the power to appoint his tribunal member. And he's the one who wants the best person, regardless of their race, gender, or what language they speak. So I don't think that diversity insofar as personal attributes play a role to the parties involved in a dispute at all. For example, and I think Abdul said this earlier, if it's a company from Africa, let's say it's a company in Botswana, and in fact I've worked in Botswana, perhaps they would feel more comfortable with a tribunal that they can relate to. Perhaps they want a African person on the panel because that's what they relate to. So if the company is owned by a white male person, then perhaps he wants a white male as a tribunal because he feels he can relate to that person. But as I said, I think that the personal attributes shouldn't actually matter. And I don't think they really matter that much to parties. I think it's down to your professional qualifications.
Well, looking at the chat box, there's quite a few people who agree with you. Bernadette.
In support of Chantelle, in support of Chantelle, yeah, I do think personal attributes are irrelevant. And I think you used a good comparison. So I think what we are driving from, we talk about a more diverse panel. You know, Chantelle, if you describe her in one way, yes, she's the best person for the job. The person will see it like that. So what we need more best persons on a panel. We need a much wider panel because, you know, there are still so many disputes to be resolved. And I think maybe we're failing consumers by not offering a service with a wider panel. Like you say, someone said, oh, someone's given up on adjudication. So yeah, we need a wider panel with everyone as the best person of whichever, with all kinds of attributes. So in simple terms.
Thank you. Well, looking at the clock, I think we're almost out of time. It's been a really interesting discussion. There's been lots of chat comments. There's been quite a few Q&A comments and questions. I'm sorry I haven't had time to go through all of them, but I hope you've all enjoyed today's discussion. And particularly, I'd like to thank all of our panel today for participating in what's been a riveting debate.